minute, and we'll get underway. We aren't amplified. Hopefully you can hear me. If we can't, just let me know, and I'll try to speak loudly and clearly for everyone in the audience to hear. We had some audio issues tonight with the microphone, but it is recording. Oh, thank you. Elizabeth Brown. Here's a credit card for you. Mike, you let me know when we're ready to roll. All right. Well, welcome to the public meeting for the Big Cottonwood Creek Subdivision General Adjudication. My name is Blake Bingham. I'm the Assistant State Engineer. I'm responsible for the adjudication efforts throughout the state of Utah, more specifically within the Utah Valley, the Salt Lake Valley, Utah Valley. As we get started, I'd just like to point out a couple key people. First of all, is Kent Jones here. He's actually the state engineer. He's in the door frame. So he's my boss. He's the man I answer to. And they also have Tamara Prue over here in the other door frame. Raise your hand, Tamara. She's going to be the team leader for this subdivision. So she's going to kind of manage the boots on the ground efforts as they go out and evaluate claims. And they have Gary Brimley, who's kind of my deputy back in the back corner back here, who also helps me manage some of these proceedings. Kind of the rules of engagement for tonight. If you have any questions throughout the presentation, feel free to raise your hand and ask them. If there are questions that are more specific to your own situation, I might ask you to table those, and then we'll answer them after this meeting. Or you can always feel free to step up and step outside in the hallway, and one of the members of my teams will help address that question you have if you can't stick around to the end. Here's the agenda. We're going to talk about the adjudication, what it is, what it entails. We'll talk about the proposed determination, some of the significant issues, the anticipated timeline, and then questions, again, we'll answer throughout, but I'll stay here as late as you want, answering whatever questions you have about your specific rights or about the process in general. For those who are viewing this program online, if you want to ask a question tonight and get it answered via live stream, go ahead and email it to that email address at the bottom of the screen, and that's an email address anyone in this room can use throughout the adjudication process. Those emails go to me. At the conclusion of this presentation, I'll look at my email and answer those questions for the benefit of the group. So take note of that. This email address will pop again at the conclusion of this presentation. So if you think of a question through the presentation, we'll circle back and you can fire one off, and I'll give some time for those to kind of register before we conclude the meeting or conclude the live stream broadcast. Okay, well, let's get started then. We typically like to give an overview of what water rights are. You know, most of us in here are not very familiar with the adjudication processes. There's probably levels or degrees of understanding of what a water right is. So I usually like to start there and do some Water Rights 101. Really what a water right is, the right to divert or remove from its natural source and beneficially use waters of the state of Utah. There's some typical defining elements of a water right. They typically include the nature of beneficial use, or in other words, what it's being used for, whether that's for irrigation, for stock watering, for domestic use, those types of things. A priority date, which indicates where that water right falls in the line of priority, for lack of a better word, in getting their water, whether they're first in line or last in line. So the earlier the priority date you have, the more senior your water right is, means you get your water before someone with a junior priority date does, okay? That's just the nature of the concept of prior appropriation that most of the western United States operates off with regard to water. There's a defined quantity. We typically measure that in cubic feet per second, which is a flow rate, or an annual volume, an acre foot per year. An acre foot, if you imagine a yard that's 1 acre and water 1 foot deep, that's how big an acre foot is, and that's typically used to measure larger quantities of water. A specified point of diversion, that's kind of a fancy word for simply saying where are they pulling the water out of the source, whether that's a head gate or whether that's a well or a spring box. That's what we call a point of diversion, okay? And you'll hear that often tonight. And then a specified place of beneficial use, and that's just as like it sounds. That's where the water is being used. And we use the public land survey system to kind of identify where that place of use exists, so it's easy to track down if we want to find it. So often when we send these notices out, I forgot to mention, I think when we send these notices out and there's a summons attached to it, it gets people a little concerned. You're really not obligated to attend this meeting. I know sometimes the summons makes it sound as though you're summoned to appear. That's kind of in the non-literal sense. It's in the legal sense that you are joined as a party in this general adjudication, but you're not required. Your attendance isn't required at this meeting. So if you feel like your curiosity has been satisfied, or at any time tonight, or you don't want to be here, or you run out of time, feel free to step up and walk out and make your way out the way you came in. There's no need to be here. So back to this. When we send those notices out, we often get a lot of phone calls asking us, well, how do I know if I have a water right? And we typically answer, well, you probably will know, because water rights require a certain level of infrastructure. They typically include you have a well or a head gate or a spring box or something to that effect that takes maintenance year after year. And so if you have those types of structures on your property, that may indicate the existence of a water right. So if you have a well, these are kind of examples of typical domestic wells in the Salt Lake Valley. They're a little bit smaller, kind of look like a little pipe sticking out of the ground. But again, you probably know about these things because you're probably either maintaining them or mowing around them or wondering why it's leaking water all the time. Or you might have a head gate that you have to maintain. What a water right is not, it's not a share in an irrigation company. I know there's probably a few shareholders in here. We have a couple of irrigation companies that are within this respective drainage. Now, a share is just like it sounds, all right? It's a share of interest in the company. The company itself owns the water rights, and then they distribute water based on this share allocation, okay? And so, although you may be a shareholder, you don't have a water right. And so what that means is that the irrigation company or the water company would participate in this process on behalf of its shareholders. Now, does that mean you can just kind of dial out and not worry about this? I would encourage you to stay involved, to make sure that the irrigation company is participating in this process. Depending on how robust the company is, they may have a certain level of expertise, and they may not have a certain level of expertise and familiarity with this process. So be engaged, be informed, and make sure that the board for the irrigation company, the president for the irrigation company understands this process and is actively engaged in filing claims and participating. It's also not a connection to a public water supplier. And when I talk about that, that's like your metered water from Salt Lake City or whatever public water supplier municipality you might receive water from. Okay, so that's not a water right. You're a customer of that service provider. Now, the person or the entity that provides that water to you owns water rights. Whenever you divert water in the state of Utah, you got to have a water right. So that municipality or that public water supplier has a water right, but they are, again, participating in this process on behalf of their customers. So when I talk about water rights and the adjudication process, it's hard to explain the importance of the process without kind of giving some historical context. So I'm going to give you kind of a brief history lesson. Bear with it. It's only a few slides, but it's important to understand how water rights in the state of Utah evolved over time to where we are today and why we have water rights, why the state even cares whether you're diverting water out of a well or out of a spring or anything like that, okay? So let's start off with 1847. We know the story that Brigham Young and an advanced party of Mormon pioneers came into the valley, and they started diverting the waters of City Creek to kind of soften up the ground so they could plant a late season crop. And then, of course, they built their shopping mall over top of it. But nearly a year later, Brigham Young made this statement that there should be no private ownership of the streams that come out of the canyons. They belong to the people. And that's really the fundamental basis of how water rights are operated in the state of Utah. The state doesn't own the water. The water is owned by the people. We're simply the Division of Water Rights, or the Office of the State Engineer, is simply an entity created to help the the meaningful and the reliable diversion and distribution of these waters. So we're just kind of the grease that greases the wheels a little bit to make sure that people's rights are being distributed fairly. Well, between 1847 and 1850, we know that Utah kind of went from being a part of Mexico to this kind of quasi-ecclesiastical state of Deseret to finally the territory of Utah. But, water was diverted, and the government was typically centered around the LDS Church, right? They're the kind of the governing power. There was no other government agency to set up much of anything at all. So, as a result of that, diversions of water were kind of done on a communal basis to satisfy the immediate needs of the settlers, right? Brigham Young would send them north, send them south, and they just start digging ditches and diverting water, raising crops wherever they went. They didn't really have this concept of, we better apply for a water right from this territory or from this state of Deseret. That's something that evolved over time. The doctrine of priority, however, did evolve as a basis of that, recognizing that the first settlers who did all the work in digging the ditches, diverting the water, got a primary right, but they still wanted to share with other settlers that came in later, and so those settlers got a secondary right. And so this concept of primary and secondary evolved into this doctrine of priority, where the first in time is the first in right, kind of like a mining claim, okay? As a result of this, conflicts were also settled through ecclesiastical channels. You had those bishops' courts for kind of minor offenses, and if you didn't like how the bishop ruled, you take it to the stake high council, and the stake high council would either overturn the bishop or whatever, okay? So that's how they settled issues back then, because there was no other infrastructure in place to resolve these disputes. Well, as we fast forward into the historical context era, the territorial era of the historical context, the first territorial legislative assembly passed a law that authorized the county courts to administer rights for timber and for water and these types of things. That was back in 1852. However, Salt Lake County was kind of the only one that really participated in that, the only one that really recognized that. And also, it's interesting to note that the county court at that time, wasn't like how we would recognize it. In essence, they elected their judges, and they could just be a lay person, and they said, well, you're a pretty wise guy, we're going to elect you. So you can imagine who they elected to those positions. It was the bishops and the stake presidents. So really, there was really not a whole lot of change with regard to how disputes were settled. In 1877, the Desert Land Act was passed by the United States Congress, and that was really to incentivize the homesteading of the arid West, okay? They wanted the people to move out west. They wanted to expand their territory. They just won this huge chunk of territory from Mexico. They wanted to populate it. And so a couple of results of that is it severed title of water from the land. Back east, if you lived adjacent to a river, to a stream, you had what was called a riparian right. You could just take the water because you lived close to it. Well, in the arid West, we don't have that many streams, and you have lots of land. And so they recognized, well, in order to homestead a piece of land, you had to irrigate it. There were some certain irrigation requirements to develop it. And that required you diverting water from a stream, taking it a long way, and applying it somewhere else. So it formally severed that concept that water goes with the land. It also delegated authority to the different states or territories to administer water rights, to administer property rights under the concept of water. And we kind of think of that as maybe a foregone conclusion a little bit, but if you think about it, it wasn't. It's kind of radical in that day, because the government land office, owned by the federal government, still issued patents for land, and you would think, well, that makes sense. Why don't we do the same thing for water? Well, this changed that. In essence, it said that the individual territories or the states were responsible for issuing water rights and administering them. In 1880, due to the failure of the 1852 Act, there was really a failure to enforce it. People didn't really bother with it. They tried to appoint county selectmen who would go around and adjudicate rights and kind of act as unofficial judges to deal with in water disputes and issue certificates. But again, it was largely ignored throughout the state, and is even found later on to be unconstitutional. So they decided to carry on. As a result of that, confusion existed in spite of the best efforts of the territorial legislature or the LDS Church. And the church continued to administer and decree water rights. common example I often cite is the 1879 High Council decision that divided the waters of the Spanish Fork River. And to this day, they are divided along those same lines that the High Council decreed back in that day. There's been some tweaks and adjustments throughout the subsequent years by courts and other things, but for the most part, those same irrigation companies own that same water that was decreed by the High Council back then. Well, as we move into statehood, in 1896, Utah becomes a state, but there was a lot of controversy because people thought that if Utah became a state, there was a movement afoot to confiscate all the water rights, to say, all right, the state now owns everyone's water rights and you have to reapply for them. And there was a big controversy over this, so they decided, well, we will just punt on the issue of water rights. We won't touch them. The only thing we will do is put this provision in the Utah State Constitution that says all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. And what that did is if you were using water, yet you were using it for beneficial use, you were grandfathered in. You didn't have to worry about it being confiscated or lost when the state came online, okay? And so we sometimes refer to those rights as pre-statutory rights. Sometimes we'll call them diligence claims, but we'll talk a little bit more about those here in a little bit. 1897, 1 year after statehood, the Office of the State Engineer was created. His mission was really to map out Utah, to conduct what we call hydrographic surveys, to identify sources of water and streams. But appropriations of water, if you wanted to use water, it was still done in the old-fashioned way where you'd go and stake a claim on the source and then go file that claim at the post office or the county recorder. So it's still kind of the old school way. State engineer had nothing to do with it. But they kind of became a little bit aware that was a big issue, that there needed to be some type of centralized system, some type of centralized body of water law, because in 1902 the Reclamation Service was organized in what we now know as the Bureau of Reclamation. Their mission was to create these huge reservoirs, and then they would deliver water to irrigators, right, and kind of help further reclaim the arid West. But the Reclamation Service was really reluctant, actually wouldn't do any projects in any state where there wasn't a comprehensive water law. Okay, and at the time, Utah didn't have that. So 1 year later, they finally figured that, hey, we better do this if we want to get these big projects in the state of Utah. So they developed a comprehensive water law, and it called for the recording of all existing rights. Remember all those grandfathered rights, as well as and adjudicating them. However, the legislature failed to fund the effort. What they simply did is said, all right, courts, it's your responsibility to figure out all the existing rights. State engineer, it's your responsibility to appropriate new rights. Well, in a court of law, a court of law is an adversarial action, right? You need a plaintiff and you need a defendant. Well, you don't expect the justices or the judges to kind of go out and figure out water rights unless there's a case brought before them. So that really didn't do anything, although it was kind of a good theory. The courts never really did anything. And the legislature didn't fund any personnel to actually go out and look for these water rights. So there was no water rights, existing water rights that were ever discovered or adjudicated, okay? And then in 1919, well, if I can back up just a bit. So in 1903, that water law was only for surface waters. You still could drill a well without a water right, okay? Well, in 1919, they finally came to the conclusion that surface water and groundwater is all the same water. They're interconnected. And so the legislature required then at that time that if you wanted to drill a well, you had to obtain a water right, the same as you would have to after 1903 for any surface waters. So when we talk about pre-statutory rights, or rights that were grandfathered in, diligence claims, for surface water, we're saying anything prior to 1903 means you didn't have to have a water right for surface or groundwater. After 1903, you needed a water right to divert anything from surface. Prior to 1919, you could still drill a well and divert from wells without a water right. After 1919, you needed a water right. So when we look at the Salt Lake Valley, there's actually quite a few of wells that were drilled prior to, you know what, I'm getting a little hemmed up. Kent's over there squirming. I'm getting ahead of myself. That's the day I'm talking about. 1919 is when the state legislature finally figured out that, hey, this whole adjudication process isn't working. We need to figure it out. And they came up with the idea that the state engineer, what he's going to do, he's going to go out, do the hydrographic survey, identify the claims, and then take that before the court. Then in 1935 was when they finally realized they needed water rights for groundwater. So forget the whole 1919 pre-statutory. It's really 1935. So in Salt Lake Valley, there were a lot of wells that were drilled prior to 1935 because there wasn't the infrastructure available to deliver water from municipal water systems. Okay, so often these subdivisions would be developed, and each house would have their own culinary well drilled. And then after time kind of went on, the infrastructure reached those houses, and they were able to tie into the municipal system, and they would disconnect their wells. So I imagine in this area, if I recall correctly, there are a lot of individual wells associated with domestic uses, or that were once domestic uses, that were probably severed once the infrastructure reached their house, and they decided, well, we don't like this nasty groundwater. We're going to take the clean mountain stream water that Salt Lake City collects and treats and distributes. So again, prior to 1935, you didn't need a water right for a well. After 1935, you did. All right, so let's talk about the historical case for adjudication. Prior to that, to those laws that implemented the comprehensive water law, water rights kind of fell into a couple different categories. You had those rights that were decreed by ecclesiastical leaders, like that Spanish Fork River decree by the High Council. You had claims that were filed for record at the county. They were just, they were trying to do the best they could. They took their claim and they filed it with the county, and that's how they had a record of their water rights. You had those rights that were decreed by a court. However, those decrees only involved distinct parties. They didn't involve anyone. So if you had parties A, B, and C, and A and B didn't like how their water rights related to each other, and they had an argument, they'd go to the court, and the court would settle the issue between party A and party B, but party C wasn't part of that decree, or that they weren't joined in the action. So they weren't bound to the decree of A and B. They kind of did their own thing. So there are limited parties, and so you had a lot of different lawsuits that had limited joinder of parties. You had contracts or agreements among limited parties. A lot of that happened in Salt Lake Valley as irrigation companies developed along the benches and diverted water out of the canyons. And as Salt Lake City grew and expanded, Salt Lake City would approach these irrigation companies and say, tell you what, we recognize that your mountain streams don't provide a full source of supply throughout the entire summer. So what we're going to do is we're going to contract with you to give you this Utah lake water, which will provide you full source of supply throughout the entire summer, and you give us your clean mountain water that we can treat and provide to customers as culinary water. So these are called exchanges. There are a series of these exchanges between Salt Lake City and various water companies or irrigation companies, which you may be a shareholder of. And Salt Lake City may actually own all the shares with that irrigation company, but they still are set up as an irrigation company. It's kind of an interesting relationship. Then you had those claims that were never manifested on in any record, but they're evidenced by pre-statutory use. These are those grandfathered rights, the rights that were used, the surface rights that were used prior to 1903, and the underground rights that were used prior to 1935. Maybe these guys just never felt like filing a claim, and they didn't really have to. So these are just people that were using rights and have never brought them onto the permanent record. As a result, there's a number of issues. First, there was no public record. There may have been a kind of a hit and miss sporadic record, but there wasn't a consolidated record anywhere where you could go to one place and find out about all the water rights in a certain area. Because there wasn't a record, over-appropriation was rampant. Often courts would decree or a lot more water than was actually able to be flowing in the creeks. That was pretty common. And often rights weren't defined until they came into controversy, until someone disagreed, and then they'd have to be settled by a court. But again, that was amongst those limited parties, so they were limited to that. In his biennial report, the state engineer, so back in 1901, 1902, you recall, this is prior to the comprehensive water law coming into effect. He said, the definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So the whole idea was, when they drafted that 1903 law, that they were going to go and adjudicate all these existing rights. They could figure out what these rights were, bring them onto the record, and then they'd start appropriating new water rights. Well, as you recall, that the law never really worked for adjudicating those existing rights. The system was kind of broken. And so what they decided to do is, like, well, we can't wait forever. People are trying to develop communities, houses, so we need to move forward. So they did begin appropriating new water rights right away. So we kind of have these two parallel paths, where you have the appropriation system of appropriating new rights and the adjudication trying to capture all these existing rights and bring them onto the permanent record. So what is a general stream adjudication or a water rights adjudication? Sometimes we just call them a general adjudication. Well, it is an action in state district court, as the name implies, an adjudication. It binds all water users and the state engineer, not just the limited parties, but everyone in the drainage. That's the title of code that it's governed by. The first general stream adjudications took place in the 20s. You will recall in 1919 is when the state engineer finally had that mechanism, the proposed determination mechanism, to do an audit of the water rights and file it with the court. So we have a bunch of the drainages that were initiated at that time. The Sevier River drainage was started in 1920, the Weber River drainage in 1919, the Virgin River drainage back in 1923, and then the court petitioned to reopen it back in the 80s. And then so you see all these different colored pieces. Those are all different general water rights adjudications. The one that we're talking about is the Big Cottonwood Creek Subdivision of the Utah Lake Jordan River adjudication. So this big purple blob, okay? That goes up into Salt Lake Valley, down into Utah Valley, down to Goshen, up into Heber. It's all the drainage of the Provo River, the Spanish Fork River, American Fork River, the Utah Lake, and the Jordan River. All of those drainage are one big comprehensive general adjudication. But because it's so massive, we have to take it in bite-sized pieces. So this subdivision is one of those bite-sized pieces. You'll note the start date is 1944. And we're finally to you guys, okay? And if you can believe it, that's literally what's been going on. We've been taking these. Now there's been kind of swells of activity. We're kind of in a rush of activity recently, but we've literally been doing bite-sized pieces of this Utah Lake Jordan River general adjudication since 1944. And it actually started in 1936. So if you look at the civil number on your notice, it starts off with a 36. That's because that's when this court case was actually implemented or instituted by Salt Lake City, who was trying to filed suit on a bunch of users on the Jordan River. The court said, hey, this involves everyone. We're going to make it a general adjudication. So it started off as a private suit between Salt Lake City and like 1,000 water users. And then the court said, hey, that doesn't make sense. We got to bring everyone. It involves more than just these individual parties. Okay, so why do we conduct general adjudications? Well, we want to bring all claims onto the permanent record. You remember this guy? He's diverting water, no cares in the world. So we often call pre-statutory rights that are surface-based diligence claims, and anything that's groundwater-based, we usually call those underground water claims. Sometimes we'll just call them all diligence claims. But that's the nomenclature for these claims that never were brought onto the permanent record. They're grandfathered rights. So we want to find those out. We want people to bring those forward as part of this process, and then they were required to. If they fail to bring those forward as part of this process, then they're barred from ever asserting that claim in the future. So that's one of the main reasons we do a general adjudication. Another reason why we do it, and this is kind of a unique feature of general adjudication, is for these things called Federal Reserved water rights. And it has nothing to do with the Federal Reserve that prints money or anything like that, okay? The background of this is back to around the turn of the century. The Fort Belknap Indian Reservation, the Indians were attempting to divert water from the Milk River, this is in Montana, to satisfy the needs, and they're trying to become agrarian-based. You know, they're put on this reservation to become a kind of agrarian-based people, and so they're trying to do that. They went to the equivalent of the state engineer of Montana and said, hey, we want to appropriate some water so that we can develop our reservation, and the state engineer of Montana said, I'm sorry, all the waters of the Milk River have been appropriated to all the settlers already. You're out of luck. There's no water for you. Well, you can imagine that didn't sit well with the Indians. They took them to court. eventually went up to the Supreme Court, and the Supreme Court ruled that by virtue of the fact that Congress had reserved this Indian reservation from the public domain, that there was an implied water right that was necessary to go along with it to satisfy the needs of the Indian reservation. So that was back in 1908. That's called the Winters Doctrine, okay? That's when the Supreme Court finally made that decision. And that had kind of a ripple effect across other types of federal reservations, because Indian reservations aren't the only type of federal reservations. There's also military reservations, there's national park reservations, there's Forest Service reservations. All of these reservations have federal reserved water rights, or have potential federally reserved water rights with them, meaning that these water rights are whatever are necessary for that reservation. So for Forest Service, the Forest Service was created, prior to the 1900, and some of our forests up here have early dates. They would say, well, what's required for us is to satisfy the needs for timber and to maintain adequate flows in the rivers. And so we have these big unknown water rights potentially hanging over our heads. The problem is you can't sue the federal government, right? They have federal sovereign immunity. So the only way that you can sue the federal government is if they let you sue them, and they're not really willing to do that very often. So in 1952, Senator McCarran, a senator from Nevada, said, well, that's not very fair. We're going to change the law. So he drafted up what was called the McCarran Amendment, which in essence says the United States waives its federal sovereign immunity with respect to general adjudications, meaning that the state can sue the federal government and force them to come to the table and quantify those federal reserved rights. And not only that they have to come to the table and they have to submit their claims to be adjudicated in the state district court. So that's pretty unique, okay? Usually whenever you sue the federal government, you end up in federal court. Well, in this case, they have to file their claims with the state engineer, and they get adjudicated in the state district court. So you can imagine it's important in Utah, where we have a lot of public lands. We have a lot of Forest Service, especially obviously in this canyon. There's Forest Service ground, and they probably have, I already do know, they do have Federal Reserve right claims in Big Cottonwood Creek. Another reason we want to adjudicate is to prevent multiplicity of suits. We don't want everyone suing each other. We just kind of want to bring everyone together, hammer it out, and get it done. Kind of a one-stop shop. All right, so here's the more controversial aspect, at least it appears to be at first blush when you look at it. So in most of the arid United States, or the West, they all have this rule of use it or lose it. As we're all aware, there's a finite amount of water, of wet water, in this state or in other states in the West, and there's a lot of demand on that water. And so what the founders of the state, or the initial legislature and most of the other states came up with the concept is they want to incentivize people to use the water. They wanted to avoid people developing monopolies, appropriating all this water and then sitting on it and kind of being the mafioso of water, right? You have to come to me to get water. And so the concept was, hey, if you don't use your water rights within 7 years, it's subject to being forfeited by the court. All right, so that's still part of the Utah law. So the consequence is if you have a water right and you haven't used it within the last 7 years, it's subject to being forfeited by the court. All right, we would go in, you filed your claim, we'd take a look around. If there's nothing there, if it's a Walmart parking lot, it hasn't been used for 7 years, we're probably going to make a recommendation to the court that the court simply forfeit it based on this law. Okay, usually this is where I get all the questions start happening. We get one person to raise their hand, then the floodgates open. We also want to obtain a final comprehensive decree on all water rights. So whether you've appropriated water rights or you have these diligence claims, at the end of the day, we want the court to issue a decree on them to certify them as valid water rights, okay, as property rights. Okay. Let's talk a little bit about the adjudication process. We're going to go into a lot of detail in the next subsequent slides, so this is kind of just a broad overview, so don't get too concerned if I kind of just lightly skim through these, all right? So the first process culminates with this meeting. The first leg of the process or phase of the process culminates with this meeting. The petition to do a general adjudication, well, that was handled by the court. The court initiated this back in 1936. We sent notice. We published notice in the newspaper. We sent summons. You received the summons in the mail. We also published summons in the newspaper. And then we're having the public meeting. So that's step number 4. That's where we are tonight. The next phase will be, again, I'll cover this in much greater detail here in the next few slides, will be to file claims. You'll receive a notice to file your claim if you have a water right. People who fail to file a claim on a water right of record for those rights that have been appropriated, and we have a whole file room upstairs with water rights. If people fail to file a claim on those rights for this subdivision, they'll go on this thing called a list of unclaimed rights. And unless someone objects to that list, those rights are subject to being decreed abandoned. Again, I'll cover that in a little bit more detail here shortly. And we'll hold a public meeting to go over that. You'll have 90 days to object. Again, more to follow on that. Really, the crux of what I want you to get out of this slide is that you're going to file a claim, and then we are going to have our staff come and meet with you in the field to evaluate the claim. And ultimately, our recommendation for that claim goes in what's called a proposed determination that is the state engineer's official recommendation to the court. All right, so that's the overview. In essence, after this meeting, you'll receive a notice to file a claim along with a claim form. You file the claim, we evaluate it, we make our recommendation to the court, and then people have an opportunity to object to that, to disagree with us, and then we can settle that through either litigation or settlement proceedings. There's a couple of different avenues, but again, I'll cover that here step by step. So this is just the general overview. And again, this presentation is being recorded, so if I've moved too fast and you want to review it, you can go to our website tomorrow or the next day, and it should be uploaded to the YouTube site on that same link that I gave you that's in your notice, okay, that watch live link. You can get to the past videos from there. Okay, so let's talk about filing your water user's claim. So in a week or two, Tamara, what's the date we're sending the notices to file claims out? The 28th of September. So on the 28th of September, we're going to mail the notice out, okay? So the notice will be mailed to everyone who received the notice and summons for this public meeting tonight. So if you have that letter tonight, you'll receive a notice, okay? And we'll also publish it in the newspaper. What goes in that notice? Well, first of all, it's going to be a notice saying you have 90 days to file a claim. But you also get a water user's claim form. Now, if you are a water right owner of record, meaning you have a water right and you're on our records, let's say you appropriated this water right or you bought a water right and you've updated your ownership with us and we have your name on our records upstairs, you'll receive a claim that's already filled out. It'll already have all the details. All you really need to do is sign and send it back to us. If you are simply a property owner and maybe you have one of these wells that is a grandfathered well, an underground water claim, or some other type of pre-statutory use, you'll receive a blank claim and you can fill out that claim. Now, it's going to be a challenge to fill that claim out, so we encourage people to come in or contact us and we'll help you fill out and file your claim, all right? And you can either file that claim with us or you can file it with the district court, the Third District Court. Again, the instructions will be in that packet you were sent. You have 90 days from September 28th in order to file that claim, all right? You can also request an extension, an additional 30 days within that same time frame, but you have to request that extension within that 90-day period if you need additional time. And that's as simple as an email. If that email address I showed you earlier, and I'll have an email address at the end of this slide, you send an extension request. It's pretty easy. Hey, I just need the 30 more day extension. I'll respond back. You're good to go. You have until this date to file a claim. It's pretty straightforward, pretty easy. It's a shall issue. I don't get to decide whether you merit or not. It's just you get it upon request. You have 90 days to file a claim. If you fail to file a claim in that 90 days, you could be barred from asserting a claim down the road. And if you fail to file a claim on a right of record, it goes on this list of unclaimed rights, which I'll cover here in a second. But once we receive that claim, my team is going to come out, is going to try to make contact with you and come out and evaluate the claim, all right? So if you say, I have a well, I'm irrigating a 1/4 acre of irrigation, we're going to come out and we're going to look for the well. We're going to make sure we get the location of the well, and then we're going to map that 1/4 acre of irrigation. So if you file a claim that says, I have this well, I'm irrigating a 1/4 acre, and we come out and it's a parking lot, Well, we're going to say we don't see anything. We're going to recommend that your claim be disallowed, okay? So we do everything we can to give the water user the benefit of the doubt. One thing I often say, and I'll say it here, is, if we come out and your well is working and you're using it, we're going to recognize that. So for those of you who have wells who may be in a state of disrepair right now, or whatever, get it fixed before we come out and evaluate it. If we come out and look at it and then you get it fixed, well, yeah, it's kind of, I don't know that we can kind of turn a blind eye to that. So do your best to make sure that you're showing the beneficial use when we get on site. For a lot of these wells, they've been severed from the domestic use, but a lot of people continue to use them for irrigation. Just make sure that there's a hose or something connected that you say, yeah, I use it for irrigation, right? Again, we're not really anxious, or we don't want to take people's water rights away. We don't want to make that recommendation to the court. We want people to use the water rights that they have. Okay, list of unclaimed rights. You recall, we have a whole bunch of water right jackets upstairs. These are water rights that have been applied for in the past. For instance, let's say someone in 1940 drilled a well for their house. Then they subsequently sold that house, and then that person sold the house. Eventually, you purchased the house. Well, the person who filed for the water right is going to be on our records upstairs. However, you are not going to be unless you update your records with us. So although you may be the owner of that well and that water right, on our records it doesn't show that because our records don't communicate with the county recorder, okay, unless you tell them to do that. There's a certain process in order to do that. But what I want to say is you don't need to do that process to file a claim. Simply file a claim. But if there's no claim filed on that water right of record that we have, it goes on this list of unclaimed rights. We then send a notice to everyone about the list. So the same people who received the notice tonight will receive notice of this list of unclaimed rights. We'll have a public meeting. And then people have 90 days to file an objection. So if you see your water right on that list, you can simply file an objection, and it's pretty easy. You have to do it with the court. You just write a narrative to the court saying, hey, I failed to file a claim. Here's my claim. So you got to file an objection and a claim at the same time, as well as give the state engineer a claim. And then we don't really dispute those. We just simply say, great, glad to see you guys finally participated. Let's move on. But you have 90 days to do that. And then we have to resolve those objections. Again, we don't really fight these very often unless there's just something really sketchy about it, okay? We can either litigate it or we can remain silent. Usually what we'll do is we'll simply file a motion saying we don't object to them filing the claim or the objection, and that the judge should allow the claim to be filed. And then once we get all those objections resolved, the judge will issue a decree on that list of unclaimed rights and will, in essence, decree that those rights have been abandoned. And what does that mean? That just means they just go away. They don't go to us. They don't go to someone. We won't sell them. They just become inactivated. We still keep them on our records, but they just become of no use. Okay. Also, what this decree does is it prevents anyone from asserting a new grandfathered right, new diligence claim. You remember the Dosecki guy who was not filing a claim until 100 years later? Well, this essentially says, hey, you're done. You can no longer file that claim. You had your chance. If you failed to do it, you're done. So those are the two consequences of that decree on the list of unclaimed rights. Let's talk about the proposed determination. As I mentioned, the proposed determination is really the state engineer's official recommendation to the court, all right? And it's going to be compiled. We're going to take the water user's claim, and then what the water user's claim, the format of the proposed determination will look a lot like the format of the water user's claim. It will show the owner of record, the flow rate, the beneficial use, the place of use, all these differing aspects of the water right in a book format, okay? We'll send out notice to people that the proposed determination has been filed with the court, and we'll provide a link on how to access the proposed determination. However, we will only send that notice to people who actually filed the claim or participated in the adjudication. So whereas we sent out, I think, 11,000 notices for this meeting, we'll probably send a lot fewer, maybe in the hundreds, for this proposed determination. in this public meeting. Again, you'll have a 90-day objection period. So if you don't like how the state engineers evaluated your water right, you have 90 days to file an objection with the court. Again, don't file it with the state engineer. We're now in the litigation proceedings, so you need to file that with the court. Oops. Let's see here. Go. Once you file that objection with the court, we have to resolve that objection. We'll either resolve it by saying, oh, yep, we screwed up. We petition the court to amend the proposed determination to correct our mistake if there's like a clerical error or we really did miss something. Or if we don't agree with the objection, we may choose to litigate it. We may choose to go to court, and then you will be on the hook to have to defend your objection in the court. And it's just like traditional litigation. Sometimes we'll seek negotiated settlement where we stipulate to amending it one way or another. So those are kind of the ways we work through some of these objections. Then finally, we'll petition the court once we've resolved all the objections. We'll petition the court for a final decree on the adjudication, on the proposed determination. In essence, confirming the status of the water rights as recommended by the state engineer, okay? Or as modified by court order based on a previous objection. Okay, so that's the process. And again, if you have questions, we can talk that through. Let's talk about the Big Cottonwood Creek Subdivision. So you probably recognize this map. It was on your notice. This map's a little bit different. It has a lot of those purple dots. All those purple dots represent water rights of record that we know of. Those represents points of diversion, okay? So you can see down here, there's a cluster of purple dots. Those are all those wells that were drilled that are associated with individual domestic lots. And then you have a lot of rights up here that are more associated with surface rights. There's some Forest Service rights. Heck, I think there's even some stock watering rights. There's the kind of a flurry of different types of rights. It's like a grab bag of surface rights up in the upper reaches of the creek. We have 421 rights of record. Most of the rights, again, are underground. And we served 11,149 people with the notice of this proceeding. In essence, we took this shape, we compared it against the records, the county recorder's records, and sent a notice to every property owner within that shape. So that's how many unique property owners there are within the boundary of this adjudication. And that's really to make sure that people who have a right that wasn't previously brought on the record get notice of this proceeding so they come forward. Let's talk about issues and anticipated timeline. Issues I've kind of already touched on: out-of-date title to the water rights. You recall, as water rights are, as people buy old houses and get new houses, the title to the water rights may transfer at the county recorder, but they don't transfer on our records. So we may not have an up-to-date mailing address or ownership information for the owner of this right. If you find yourself in that position, you can file what's called a report of conveyance, which in essence kind of traces the lineage of the title ownership, the chain of title from the original appropriator and the original property owner forward to the present day. Also, we have these things called NPRs, or no proofs required. Back in the 30s and 40s, there weren't a lot of civil engineers or surveyors that were around to file proofs on appropriation. So to kind of give you a thumbnail sketch of the appropriations process, if you appropriated new water right, you would file an appropriation, and then you'd have 7 years to put it to beneficial use, and then after 7 years, you'd be required to file proof on that appropriation. And part of that process is either an engineer or a surveyor would have to file a proof on it, okay? And that part of that is that they would have to go and locate the point of diversion by survey. Well, during that time frame, a lot of people were engaged in World War II. There weren't a lot of surveyors or engineers around, so the legislature said, well, let's allow people to apply for a small amount of water, and we won't require them to file proof, which was great. The only problem is that there was no surveyor or engineer that tied down the exact location of where that well was or where that headgate was. And so I'll show you here in a little bit. You remember those clusters of points of diversion. We have that on a graphical interface that I'll show you after the meeting here, and it will show where these wells are located. Well, if it's a no proof require, that well might show up in one spot, but in truth, it may be located somewhere else because there was a bad description when the person applied for the water right in the first place. So there's just kind of, you have to take some of the locations of these wells or these points of diversion with a little bit of a grain of salt, okay? And we have big maps, Tamara. We have the maps of all the points of diversion outside and the back. So after this meeting, you'll be able to go and look and see your house and zero in to see if there's a point of diversion nearby or on the property. Let's talk a little bit about the anticipated timeline. September 28th, that's when we're going to send notices out. Kind of talked about that. You have 90 days to file that claim. December 27th is when that claim filing period would conclude, and the state engineer would then begin investigating those claims. Around April 2019, we're hoping to publish the list of unclaimed rights. At that time, the 90-day objection period for the list of unclaimed rights would begin. In July, it would conclude. And then around February of 2020 is when we're hoping to publish the proposed determination. You recall this, the state engineer's recommendation to the court. Again, the 90-day objection period would start on the day that we sent the notice. So when we file that with the court and send the notice to everyone, that's when that 90-day period begin, and it would conclude in around May. I think these timelines are a little bit fluid. It depends on how complicated some of these water rights are to evaluate, but this is kind of a general estimation of when we expect these benchmarks to be reached. Okay, so some commonly asked questions. Will I lose my water rights? If you're a water user and you're using your water right in conformance with the records on the state engineer's records, you have nothing to worry about so long as you file your claim, all right? You need to file your claim within the prescribed time frame. Individuals using a water without a water right of record are required to file a claim or risk being barred. You don't want to miss that time frame. And then lastly, if the water use authorized under the water is fallen out of use for 7 years or more, the water right or even a portion of it might be subject to forfeiture. We'd recommend to the court that it be disallowed based on how much was not being used. Who can I contact? That's me at the top. That's my personal email. Again, that other email that I'll get here in a little bit will go to the same place. Gary Brimley, my deputy, it's his email. And then Tamara Peru is really the person you want to contact. She's going to be directing the boots on the ground efforts. She's going to have her staff out there evaluating claims. So she's probably the best person to call. But again, any of us are more than happy to help you out if you have any questions or make sure we get you pointed in the right direction. Yes, sir. You identified here that they have record of what our water right is. Maybe. Okay, so let me just. Yeah, let me restate your questions for the purpose of for everyone. So he has a well that was drilled back in the 60s by his father. Presumably there's a water right of record. There should be a water right of record for that up in our records. But he has no idea how to access that or look for it. I'm going to show you really quick on our data on our website how to navigate. We have an aerial imagery interface so you can kind of navigate to your house or even type in your address and see what is nearby, and then it'll identify the water right associated probably with that well. So we'll use your well as an example. I'm assuming that water right has some limitations. Yeah, you're right. The water right has some limitations. It probably has, the limitations would be the flow rate, what's its maximum flow rate. It'd have a limitation for what it was authorized the beneficial use for, right? So typically these wells would be authorized one domestic unit, one house. We use the term equivalent domestic unit or EDU, and sometimes they'd have a little component of stock watering or a component of irrigation. But those limitations, I'll show you how to find those from that interface. Okay, it's a pretty slick interface. It'll answer a lot of the questions. So we almost got through without any questions. That would have only been the second time that's ever happened. I was wondering if it was going to happen, but honestly, if you have questions, ask them, because I guarantee you there's someone else probably wondering the same question. So I'm happy to answer them for you guys and the benefit of the crowd. So we'll start off here. Yes, ma'am.
Okay, so you said that we might be put to irrigation company or something. I don't know. I'm starting to wonder. And so how do I find out if my irrigation company is participating, or how do I?
Yeah, good question.
I do have irrigation, but I don't know if I have my own water right.
So her question is, she's unsure whether she's connected to an irrigation company or whether she has her own water right. How do they find that out, and how do they know if the irrigation company is participating? So first question, how do you know if you are connected to an irrigation company or if you have your own water right? Typically, if you're hooked into an irrigation company, or if you're receiving water from an irrigation company, you're going to be paying a yearly assessment to that company, okay? If you're receiving water through your water meter, you're probably not associated with a irrigation company. There are some examples that is the case, where Salt Lake City's acquired the irrigation company and then you get a discounted rate for irrigation. Those are kind of the exception to the rule. So usually you'll pay an assessment to the irrigation company. If you're not paying an assessment, my question would be, well, how are you receiving the irrigation water? Is it coming through a pipe, or is it coming through a ditch? So if it's coming through a ditch and you're not paying an assessment, you may be a successor in interest to a decreed water right, or a water right that's on our records. You just don't know about it, okay? More than likely, those ditch water rights, so for the most part, a lot of the water rights that are, or water that's come through these ditches, have been gobbled up by Salt Lake City, and they simply provide water, and you simply are just paying the public utility bill. But that, I don't know. We could look at your case, and that's, so how are you to ensure that your irrigation company is participating? Well, if you have an assessment from the irrigation company, you go and attend the yearly board meeting or the bi-yearly board meeting, whatever, and say, hey, are you guys doing something about this? Or you contact the president and make sure that they're tracking. They should be. All right, was there? Yes, sir.
So those of us that are here representing neighborhood wells, does every member or EDU of that neighborhood, or in our case it's a corporation, have to come in and file a claim?
It's a great question. So in this gentleman's particular scenario, there's a corporation that owns a well that serves an entire neighborhood, okay? It sounds to me like the corporation owns the water right associated with the well. So okay, so that's how it's listed on our records. Then that's the case. Okay, so in this case, the corporation owns the water right that services all of these different domestic residents. And so you might be an HOA, might be a PUD, whatever. In this case, it's just an entity. The entity itself would file a claim on behalf of all the people who use water. So it's whoever the water right owner of record would be responsible for filing a claim. Okay. Yes, sir.
We have 2 shares of water shares in the Brown and Sanford irrigation. They sold it to the city, and we get the discount.
Mm-hmm.
Through the Salt Lake City, and I guess you would have a record of that.
So yeah, so that's a good question. So in this gentleman's example, which is kind of becoming more and more common, he had 2 shares in the Brown and Sanford ditch off of Little Cottonwood Creek. It's an old decreed right. However, Salt Lake City has acquired the water rights associated with that, and they pay an annual assessment to Salt Lake City and get the discount for the irrigation water. His question is, do I have to file a claim on that? My answer would be no. Salt Lake City is filing a claim. You're always more than welcome to file a claim on it if you'd like. We'll just put it on the water right associated with Salt Lake City's claim, okay? Yeah, so the long and short of it, if you are 100% sure that Salt Lake City owns the water right, I guarantee you they are filing a claim and are pursuing it. And you don't need to worry about filing a claim. Yeah. I'm pretty sure that's the case. I'm trying to hedge my bets a little bit because there's always these people, there's always the cases where people will take what I said and say, well, you said I didn't need to file a claim, and then it comes back on me. So I'm saying if you are absolutely 100% sure that Salt Lake City owns your water rights, then I'm trying to assure you that Salt Lake City is participating. Matter of fact, we have monthly meetings with Salt Lake City as we go through this process and cover these different canyons and these different decreed rights. Yes, ma'am.
I'm curious about how beneficial use is measured.
Okay. So she's curious, how is beneficial use measured? Well, let's take a couple of different types of beneficial use and say what we would look for. So let's talk about irrigation. That's a common beneficial use. We would come out and we would look, well, is there stuff growing, right? And we'd map how many acres of irrigation, because that's the measure of beneficial use for irrigation, is acres of irrigated property. All right. Another type of beneficial use might be a domestic unit. And we'd come out and we'd say, is your well connected to your house? If it's connected to your house, then we would recognize that as being servicing that house, and the house would be a beneficial use for that particular well or that water right. Same thing with stock watering. We count the stock. We count how many cows there were, or chickens, or whatever. So it's pretty straightforward. We just go out and see if the physical use is manifesting itself. Okay? Yes, sir. What are dipping rights? Ah, sweet angels of mercy. So the quick answer is there's no such thing. The real answer is there was once a time when you didn't really need a water right. Residential and stock watering was kind of assumed to happen along this ditch. So if water was coming out of a canyon and there were cows nearby and people had houses, you had these dipping rights that it was assumed you were using for those rights. So would we recognize those today? If they were decreed and said you had dipping rights for so many head of stock or like a domestic residence, we would say, yeah, we will recognize that as a domestic unit of water. Kent, do you have anything more to add to the concept of dipping rights at all? I mean,
there's an old Supreme Court case in Utah, Adams v. Portage, that says that if there's water there and you have cattle moving, that they can stop and drink, or if you're a person walking by, you can dip and drink. You don't have to have a water right. But it did not give them a water right to guarantee that that's going to be there. So I think if we have ditches, if you can show that, yeah, I've been dipping water out of here before the law went into effect, and I've kept doing that and continuously use it, has been 7 years since I haven't used it, there probably isn't grounds to file a claim
sure.
on that. But drinking out of ditches stopped it.
Yeah, I know some people down in southern Utah still do that, but yeah. Yeah, file that claim. Bring your, yeah, never mind, I won't go there. I was going to say bring your Giardia impact card with you. But let's go to here, and then I'll come back to you, sir.
So how do you, another measurement question, how do you measure like flow? So if your water right is 7 acre feet, like how do you determine that you're like, no, they should only have 3 or?
So that's a great question. So this question is, how do you measure flow? So if you determine that a water right is supposed to be 7 acre feet, how do we say, no, it should only be 3 acre feet or something? Well, in truth, it comes back to the beneficial use. So in Utah, the beneficial use is the basis and limit and measure of the water right. These other features like the flow rate, the annual diversion, those are all just kind of ancillary features of the water right. So what we do is we say, all right, if you're irrigating 1 acre of irrigation, okay, we're going to say the duty. So in Utah, we have this thing called duty. And that means for this type of use, it takes this much water. So for this part of Salt Lake County, the duty is for 1 acre of irrigation, you need 5 acre feet. Okay, so the duty is 5 acre feet per acre. And so really what we're going to say is, well, let's measure the beneficial use, then we'll apply that duty value, and that will determine the extent of the amount of water you have, right? The actual flow rate is more commonly used for surface diversions when you have to measure how much a person is pulling out of a stream. And those are usually remnants of old decrees. Often the court would decree you get so many second feet or cubic feet per second, and then we hold on to that because that's how the river was distributed. So we would come back and say, all right, your water right consists of so many second feet it's quantified at this many acre feet, and this is the beneficial use. But we have these formulas to figure out for like a domestic unit, a house. We've come up with a duty of it takes 0.45 acre feet per domestic unit. Okay, so we have duty values that are applied to these types of beneficial uses, and that's how we come up with those volumes. Hey, let me go to this gentleman back here really quick and I'll come back. Yes, sir. Okay. That's a great question. So his question was, how often do we have to go through this rigmarole that the state's imposing upon us, right? Are you going to bring us back in 7 years and we're going to have to show this all over again? No, in theory, once we come through with an adjudication, that's supposed to settle the issues. Now, that doesn't prevent people, if you stop using it, your neighbors might be able to take you to court and unilaterally say, hey, he stopped using his water right. I want you to forfeit it so I get more water. So you can always have that scenario. But as far as the state is concerned, once you file proof or once you go through an adjudication process, the theory is we've had our opportunity to evaluate the water rights. It's a snapshot in time, and we drive on. Okay, unless the court orders a re-adjudication of the rights, that's the only time we'd come back. And I've only known that to happen in a few instances. Okay. You had a question, sir? Okay. Yeah. Yeah, so it's a great question. So this is a gentleman, they're trying to get a water right, okay? So back in the old days, you could just appropriate a new one, but the Salt Lake City or the Salt Lake Valley has been closed to new appropriations. We have a lot more paper water than we have wet water. State engineer decided, hey, that's untenable. We're going to close it to new appropriations. So really the only way to get a water right is to buy it from someone else and then file a change application to move it to where you want to use it and divert from, okay? Now, there are certain limitations on what rights you can acquire and move. First of all, you can acquire whatever rights you want to, right? Go for it. God bless America, capitalism, all that good stuff. You can buy whatever you want. But as far as what you can move to your property, that's a whole nother issue. And so there's certain restrictions in Salt Lake Valley about how far you can move water from one source to another. And then there's also issues that if you buy a surface water right that's subject to being kind of a curtailment at the end of the season, it doesn't provide that much water, and you want to move it to a more sure source like underground, they might reduce the amount of water, recognizing that, hey, if you were diverting this out of the stream, you wouldn't get all that water. And they'll say, we'll give you that equivalent block just on a reduced basis here out of this well. So, but the regional office, the Utah Lake Jordan River Regional Office, would be able to help you through that process. There's also several online, not affiliated with us at all, exchanges where you can look up to acquire water rights. I think there's UtahWaterRightsExchange.com or something like that. I mean, KSL. There's places you can buy water rights all over the place. Buyer beware. Make sure you know what you're buying. Make sure that it's been used in the last 7 years, because if you try to buy one that hasn't been used in the last 7 years and you try to file a change application, it's going to get jammed up and probably not approved. Okay. Other questions? Yes, ma'am. Okay, so she has a culvert in her yard. It's falling apart. There's a lot of flooding going on. Who's responsible for that? Well, it kind of depends. Is it a stormwater culvert or is it used for irrigation purposes? Do you know? It's for irrigation. If it's used for irrigation purposes, it's going to be the irrigation companies responsible for maintaining that, okay? Now, if that irrigation company is now owned by Salt Lake City, then I guess that's Salt Lake City. Now, if you're trying to figure out who that irrigation company is, we might be able to help you by looking and making some assumptions. But the best thing to do is to follow it and then find someone who's using that water and ask them what irrigation company they're paying their assessment to. Yeah. So yeah, you might have to do some sleuthing. Yes, sir.
Once the proposed determination is sent out and say it's affirmative, do we as a claimant have to do anything more past that?
Yeah, so good question. So once the proposed determination is published and filed with the court, and let's say, so we've sent it to the court, and that's kind of a pretty solid level of being affirmed, and then the court decrees it, and that's the gold standard, right? Does the claimant have to do anything? No, you don't have to. The only responsibility you have is if you disagree with it and you want to file an objection. That's really the only responsibility at that point.
One more. Can a specific municipality override my use for what I'm using my water for? So I have a water right. I've been told by a specific municipality that I cannot use it for culinary water. I can only use it for irrigation.
So his question is, can a municipality boss him around about how he can use his water right? He has a water right. It's for culinary, or the city's telling him he can only use it for culinary purposes.
I can only use it for irrigation.
Oh.
I cannot use it for culinary.
Okay. So the city might be, or the municipality might be looking at the water rights record, and if there's a limitation, if the water right says, hey, you can only use it for this purposes, that may be what they're saying. Can they do anything to tell you? I mean, they don't really have a lot of tools in the shed. But the only thing they could do is they could snitch on you to the state engineer, and we have an enforcement engineer who would handle that. And really, that's just one guy for the entire state of Utah, right? So that's really the only tool that the municipality might have to force you to do the right thing, or to force you back into conformance with whatever your water right is authorized, if in fact that's what's going on.
Originally, it was set up for culinary stock and irrigation.
Okay.
And so when we purchased it, it was the city, Sandy, did not want us to actually have it.
So let's talk offline, and we'll look at yours. Okay. Yes, sir.
You spoke about transfer and purchasing water rights. When they purchase those water rights, do they have to use them within 7 years? Since they're not, I mean, a lot of them are just buying the rights, they're not actually using the water.
So his question is, if someone acquires a water right, are they obligated to use it within 7 years? The answer is yes. Or otherwise, it could potentially fall in a forfeiture. There's a few exceptions to that rule. Okay, here are the exceptions. First, there's these things that they can file something called a non-use application, which kind of freezes in time, saying, hey, I'm not going to use it for the next several years. So that period of year that's covered by that non-use application doesn't count towards forfeiture. Okay, so it kind of locks out. Another thing that prevents assertions of forfeiture, if there's an approved change application on it, it frees it, because who knows, they could be trying to change it and move it over here. So that's an ollie oxen free. And then the last one is if it's acquired by a public water supplier prior to May 5th, 2008, they are not subject to forfeiture.
Those non-use applications can be looked up on any water right?
Yes. So and I'll show you how to access the database, and you can look to see if they have non-use applications on them. Yes, sir.
On that same vein, does that mean that you have to use it, or it has to be used? Can you lease it?
That's a good question. So if you're the owner of it, do you have to use it, or does it just have to be used? Can you lease it? The Supreme Court has ruled that as long as the water is being used, it's not subject to forfeiture. So is it legal to be used by someone else on a different place of use or different beneficial use? No. So if you're going to lease it to someone that's going to use it outside of the authorized place of use or for a different use than authorized, it's still illegal, and you can still have an enforcement action, but it wouldn't be subject to forfeiture. So that bottom line is, no, you don't have to physically use it, but it just has to be being used. Okay, just be careful, because there's still some legal implications there. Sir, and then I'll come to you.
I may have missed it, but did you explain how we go to the database and get the information?
No, I'm going to do that here in a second. So let me just take this question, and I'm going to do that, and then I'll answer a more round of questions in case everyone's hanging around. And I'll also look online and see if anyone's emailed a question in. Sir?
I belong to an HOA. We bought our property back in 1963. I'm not sure if I should file when I receive this form
So his question is, he belongs to an HOA. Back in the 60s when it was developed. When they receive the form, should he file or should he assume the HOA will file on his behalf? And I would always say it's always dangerous to assume, right? So you may be probably, if I were in your shoes, I would probably approach the HOA and say, hey, are you paying attention to this? You need to file. And if they don't, then I would file just to preserve the beneficial use if they have water rights. No, there's no harm. Just more paperwork for us, but that's okay. It's what we get paid to do, right? All right. Hey, I'm going to go to show you guys the web interface really quick. Actually, let me look online and see if anyone's emailed any questions here. Okay, so got a couple questions really quick. Laurie Coburn, we have water credits. Do we need to do anything with this adjudication? Laurie, I am not sure what water credits are. I think I saw a letter from one of the companies that's owned by Salt Lake City use that terminology. Laurie, you may just need to come in and ask us because I might need more information on what a water credit is before I can answer that question intelligently.
Just to go along with that, we're kind of in that situation. We had irrigation water. As far as I know, the city took it and they give us so many credits.
Okay, so that is the scenario. So based on what this gentleman is saying, he kind of talks about the credits, is that Salt Lake City has acquired the irrigation company, and they give credits to water users as customers. You could pay like a yearly assessment. I think I saw someone in here with a form, a gentleman that showed me his letter. They pay like $325 an annual fee, and then they get a discounted rate for irrigation during the summer months. So if that's the case, Laurie, if that's what you're describing, then the answer is that Salt Lake City is the irrigation company and or Salt Lake City would be responsible for participating on your behalf, if in fact that describes your situation. All right, Tony, does filing the claim with this adjudication change the original owner's name to the current owner's name of the specific water right? That's a great question. So he's asking, if we have one of these old water rights of record and I file a claim, does that then update your records? The answer is no. The problem with, they used to do that, but the problem is if someone files a claim and just decides to say, I'm now the owner of this guy's water right, you can see the challenge with that. So there's a specific process called a report of conveyance that you need to go through online that traces that chain of title back to the original appropriator and brings it forward. Now, can you file a claim regardless of whether you're the owner on our records or not? Yes, and we encourage you to do so. We encourage you to pursue both in parallel, but you don't need to have the title updated before filing a claim. Okay, there's one more question here. Who files a claim for a water share with an irrigation company? This is from Barb Johnson. Well, I think I've answered that. The irrigation company should be participating on behalf of its shareholders. They are responsible for filing a claim. Again, if you feel really concerned about it, you can file a claim. We'll simply place it on the water right associated with the respective irrigation company. Okay. All right. So let's go quickly to this, and then I'll answer another round of questions. All right. But I wanted to show everyone our database. Let me fix the projector really quick to kind of shrink it in here. And just for the sake of the online community, bring the mic over. Let me connect here. Actually, I'll just do this one. It's a lot easier. Great. Okay, let's go to water rights. Okay, this is our homepage, waterrights.utah.gov. All right. From this screen, you can access a lot of different features. I'm going to go to the map search feature first, just because it's going to be the easiest way for you to determine whether you have a water right in your backyard or not. Okay. So you see this icon right here that says map search. Okay. Select that link, and it'll bring up a big aerial image of Utah. Just to avoid delays, I'm going to deselect this box that says points of diversion, just because it gets really busy really fast. And what I'm going to do, though, is I'm going to select this box that says adjudication books, okay, just to show you that all the subdivisions, and including this subdivision we're talking about. But this gives you a sense of all of those bite-sized pieces we're trying to work our way through. So we'll just zero in on Salt Lake Valley here. And keep on scrolling here. Sorry, it's really hard to do without a mouse. Okay, so here's the Big Cottonwood Creek adjudication boundary. Okay, you can see the big purple line that reflects similar to the line on your map. You see that over there. Okay, I'm going to zoom in onto the more residential side, all right, just because, well, actually, let's do your example first. Let's say we're not very good at navigating via aerial imagery, and we just want to find something for our address, okay? You go to this search tab over here, and you can do this drop down, select the drop down, and select address, okay? What's the address of your residence?
6450 South, 2196
East. And I know it's not Salt Lake City, but it'll still work. Okay, so it's going to place a red X. Is that your house? Okay. So it's going to zoom in to the location of that. And right now there's nothing showing because I don't have the points of diversion selected. So I'll go back to here, and I'm going to select points of diversion. And there's your well. You see that red well icon back there? So in this, and you can zoom out, it will start to get pretty busy pretty quick. But I'm just going to zoom out really quick before I select it. But you can see there's more and more wells scattered everywhere. But I'm going to select on this icon. So let's say this is your house, this is your well. So that 57-8392, that's the water right number associated with that well. Okay. Now again, I wouldn't get too wrapped around the axles about the physical location of, I'm not sure if your well is truly in the back, in the southwest corner of your property or not. Great. So this one actually is where it's supposed to be. If I select on that, it'll give a summary of the water rights information. These are kind of, don't get too worried about the code words. I'm going to show you a little bit more, but this, the status, this means it's an application to appropriate that's been certificated, meaning that someone has filed proof on it, and that's probably why it's located in the correct location. The priority date is filed actually back in 1978, August 3rd, or July 3rd rather. The uses are D for domestic and S for stock watering. The flow rate is 0.052 CFS. That's the owner we have on our records, Robert C. and L.C. Brady. The type is underground. The location, that's that public land survey system that we use to kind of identify these points. I won't go into great detail there. But if I select the hyperlink on the water right number, that will take you to our database, okay? So this has kind of a summary of all the characteristics of the actual water right. And this is these are a lot of the same details that will be included on the claim that will be sent to 2196 East 6450 South, okay? So you'll probably receive two notices, one addressed to whoever the current property owner is, as well as addressed to Robert C. and L.C. Brady, okay? And you probably already did receive two summons, I'm guessing. This just has more information. We'll just kind of scroll down a little bit to kind of get you the beneficial uses are down here in this use of water table. So it's authorized 2.85 acres of irrigation, 5 stock units, so 5 cows or horses, and when 1 EDU. Again, EDU stands for equivalent domestic unit, or 1 house, okay? This is just where it's used. It's used in the southeast quarter of the northwest quarter of Section 22, Township 2 South, Range 1 East, Salt Lake Basin Meridian. For those of you who are not familiar with the public land survey system, I wouldn't get too concerned about that. So this gentleman back here asked about, well, can we see if there's non-use applications or the status of it? If you go to this drop-down menu right there and select it, there's a couple options. One of them being scanned documents. So that was just a summary. This is all the documents that are on our files that we have upstairs. They've all been scanned into this electronic database. You can see in the natural order, there's the certificate that the state engineer issued. There's the proof that they filed along with the proof map. They had some applications down here, application to appropriate, so that started it. You can kind of sort these by date. Right now, they're just in the scanning order, but if you sort them by date, that kind of gives a little bit more sequential feel for things. So down here at the bottom is the application to appropriate. That's what started the whole thing. Then they had to get approval. Then they filed a proof. Then the state engineer issued a certificate on it. And then these are things, looks like you've had some temporary change applications filed on it back in the 90s. So that's a classic example of how you can access the information for water rights. So let's go back to this map, okay? A lot of other features. You can kind of play around. You can change the different base maps. You can use, we have a host of aerial imagery. We also have some topo maps if that's your thing. Other tools, if you know your water right number, let's just say 578728. And let's get rid of this one first. We hit search. It'll take me to that water right number. This is a water right number from a previous subdivision that we had a public meeting on. So there's lots of different tools. If you're curious what the location of a place is, you can select it. So you hit that, and it will give you the longitude and latitude, and you can convert the coordinates to the public land survey system if you want to if you really want to figure out how to file your claim on your own and you want to identify where the point of diversion is using PLS, you just use this. You just say select the closest section corner, convert coordinates, it'll take you to this, and that will give you the PLS description for that spot is south 444 feet, yada, 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 yada. And that's the public land survey system description of the point of diversion. Are there any questions about this feature? Yes, sir.
So, does he have to do anything?
Yeah, he has to file a claim.
Even though all of that information is already there?
You betcha. And if he doesn't, it goes on the list of unclaimed rights. Yes, really. Yes, ma'am. So her question is, if your water rights only authorized for domestic and stock, but you're using it for irrigation, is there an issue? There is an issue in that you're using the water right outside its authorized purposes. However, the fact that you're doing that continues to preserve it. You simply need to file a change application. So we'll come out and we'll make sure that whatever you're using continues forward, doesn't get forfeited, but we'll put a little note at the bottom that says a change application needs to be filed to conform with Utah law. So there's an issue, but just we want people to conform with the requirements. Yes, sir.
If your water right comes from Salt Lake City, something has changed with it, will you need to do anything, or will Salt Lake City do it, A, and B, can Salt Lake City's rights be forfeited if they don't do it right?
So it's kind of a lot in that question. So his question is, if your water right comes from an exchange with Salt Lake City, do you have to do anything, or is Salt Lake City going to take care of it? Right? That was A. So I'll answer that first. It kind of depends on the nature of the exchange agreement. In some instances, Salt Lake City acquired the actual rights. They own the rights. In some instances, they just exchange Utah lake water for fresh water, and your company is still the company that needs to file the claim. So in the case where they actually acquired the rights, Salt Lake City would have to file a claim. If they didn't acquire the rights and they're just they're a true exchange, then the irrigation company would need to file a claim. Now, with regard to Salt Lake City, can they have their rights forfeited? Back in 2008, the law was changed so that public water suppliers are protected from forfeiture under certain circumstances if they acquired the rights prior to May 5th, 2008, or if they acquired them afterwards, they have to file a change application. So traditionally, probably not. And any shares owned by a public water supplier are also protected. So if you have an irrigation company that has 100 shares, let's just say they have 100 acres of irrigation, and they say 1 share is 1 acre, and Salt Lake City gobbles up 80 shares, those shares are now protected from forfeiture. The other 20 would not be. Does that make sense? Any other questions? All right, if there are no other questions, I'm happy to stand here and answer your one-on-ones, and we can chase them down the rabbit hole all night. All right, thank you. Thanks. Yeah, thanks.
I do have one question.